the first session of this conference on institutional arbitration, the way world arbitrates. We have our moderator, Mr. Tejas Karia. Karia is a partner at dispute resolution practice at Shardul, Amarchand, Mangaldas and heads the firm's arbitration practice. We have Mr. Abhishek Sharma, who is a partner at Legal, who has substantial experience at various fora, including the Supreme Court of India, especially the aviation sector. We have Ms. Dipti, who is a senior general manager at Mahindra and Mahindra, who heads its litigation team practice and of its group of companies. We have Ms. Karishma Vora, who is a triple qualified lawyer at England and Wales, India and DRC Dubai. He is a barrister at 39 Essex Chambers. We have Mr. Vineet Bose, who is a senior vice president legal and general counsel at the Nuvoco Vistas group. Over to you, Mr. Karia.
Thank you. Good afternoon, everybody. It was supposed to be a morning session, but as we had so many dignitaries leaving, so we got a bit late. But we'll try to wrap it up within time so that you're not delayed for your lunch. So the topic for today's first technical session is institutional arbitration, the way world arbitrates. We heard a lot in the plenary session with regard to how India should arbitrate and how India should adopt various models. But what we need to do is that we need to see how the others do the arbitration, the way they do arbitration. It's not that we don't know how to do arbitration. The way we do arbitration for our domestic arbitration, and when we go outside, we are the same lawyers, but we apply different standards, different set of preparation, and the approach towards arbitration changes. I asked myself why we are having this kind of different approach towards arbitration and what we can do differently to have the uniform standard for doing arbitration. And the only answer is to go for institutional arbitration. Because I have always seen that all my international arbitration, 95% or more than even 99% cases are governed by institutional rules. Whereas in ad hoc, this is between 60% is institutional and 40% is ad hoc. Fortunately, but I've seen many people are only doing ad hoc arbitration. We have heard in morning session what's the difference between institutional and ad hoc. So we are not going to repeat everything what we have heard because most of the things you already know. What we are going to discuss in this panel discussion is practical aspects. How actually we should make a difference. What is that from our experience we should do that the institutional arbitration becomes more popular in India. All of us are the stakeholder in this entire process of arbitration. Why we are here together is to discuss what we can do to make a difference in the way we arbitrate. And we have to provide the services to our users who are the users of arbitrations, and ultimately we need to give them the satisfaction after the entire process is over, starting from the appointment till the enforcement of the award. Because it's not that you may expedite one part of the arbitration process, but the enforcement takes its own time, and the whole purpose of going for arbitration is defeated because you are not achieving the end-to-end result for the entire arbitration process. So let us start. We have a stellar panel today, very well experienced in arbitration matters. We have from international perspective, from in-house perspective, law firm perspective. So we are going to give you a completely 360-degree view of the way the world arbitrates and how India should adopt the arbitration. So if I may ask first question to Dipti, what we have seen is that there is a preference to ad hoc arbitration, but we have to move towards institutional arbitration. There is no two way about going for institutional arbitration. So what is in your experience? You have seen the difference between institutional arbitration and ad hoc arbitration, and according to you, what is the advantage of institutional arbitration? Because ultimately, let us hear from you from a practical perspective that how we should think about arbitration when it comes to choosing between domestic ad hoc or domestic institutional. Because we have seen international, we go for institutional in most of the cases. But when it comes to domestic arbitration, what all you have done differently so that we can adopt those best practices to go for institutional arbitration?
Thank you, Tejas. Good afternoon, everybody. Thank you for being here. I took over as litigation head at Mahindra's 6.5 years back. And back then, all our dealership agreements, service provider agreements had ad hoc arbitration as a mode of dispute resolution. They also had either a single arbitrator chosen by us or sometimes 3 arbitrators. And when I joined and arbitrations were ongoing, the older matters, I found that the arbitrations were going on for 2 years, 3 years, a longer period of time. The judges were appointed and there were various adjournments. At that point of time, yet the amendment in 2015 had just come in. So the effect of that amendment took a little longer, and therefore at the end of the day what I noticed was that our arbitrations, which were ad hoc, went on for over 2-3 years, 4 years sometimes, and it was completely at the discretion of the judges to provide adjournments, and the judges were usually senior, ex-retired High Court judges. So this concept of having younger people, senior counsels, junior counsels, etc., which is now adopted by MCIA, was not there. Once I came in and we moved to institutional arbitration, all our new agreements have MCIA as the institutional arbitration institute, and all the old agreements also got amended. With that, there came a new change. We started filing arbitrations, I think 2017-18, before MCIA, and within a period of year, 6 months, 1 year, our arbitration started getting a conclusive end. We were very, very happy with the way the entire administrative part was dealt with by MCIA. So we had no issues. There was people writing mails to us, here's the arbitrator, this is the arbitrator who we've appointed for you. If the parties had an issue, then parties had to come across and say, yes, we have an issue. There were never, or at least except for one matter, there were no Section 11 applications filed contesting the arbitrator appointed by MCIA. And we've got awards in our favor. Some of them have been ex parte because the dealers or the service providers have not appeared. Some of them have been contested. But we've had awards within specified periods of time. Arbitrators are extremely well versed with their subject matter. They're young. We, in turn, from a very, very practical perspective, there are 2 businesses. One is farm equipment business, which is farm equipment sector, and one now is Mahindra Trucks and Buses division. We used to earlier on, because arbitrations took so long, only file 138 applications, such that they would be brought on the negotiating table under criminal proceedings, because ad hoc arbitrations did not yield too much result. And that was the only strategy that we had. However, once we had MCIA, the businesses, we could tell them, look, you want, it's a 40 lakh claim, this is going to be the amount of MCIA fees, arbitrator and administrative fees. This is going to be, we started getting smaller law firms, single person man law firms who were very, very good doing end-to-end arbitration themselves. There was no need for counsels to be appointed. So that really helped the entire process. The law firms gave us a capped fee code. So at the end, I could tell business that if you want a 40 lakh claim, this is going to be your cost of arbitration, this is going to be the budget, and this is going to be the timeline. When that started happening, business got more and more motivated, because it's not like they didn't have debt. They didn't have problems in recovery. They had a lot of, so slowly and steadily, we were, after 1 or 2 arbitrations, and when they got concluded, we were able to convince business that yes, we have an award in our favor. And thereafter, we could file multiple arbitrations before MCI. So the business was willing to put its claim, saying, okay, this is a 3 crore claim, this is going to be. Amounts were payable in tranches. So we were able to tell our business, the legal team, that look, you're going to get some results here. And there were dealers in the middle who came in and said, let's settle the matter. So I come from a very, very practical experience. I'm not going to talk about cost effectiveness and all the things that were said previously. I can only say, so I'm not just propounding MCIA or institutional arbitration, but as an in-house counsel, I can say that I've seen a difference. I will just say one more thing. In ad hoc arbitration, after the amendment, and to be fair to ad hoc arbitration, after the amendment, if we have the right judge or the right person arbitrating under the ad hoc arbitration, and I will give one name of a judge whom I have held ad hoc arbitrations as Justice Rebello. And he is one person whom I have concluded arbitrations, ad hoc arbitrations, with no nonsense attitude, absolutely within 1 year. But I couldn't get, if I was still continuing ad hoc arbitration, I couldn't get that many kind of judges who would maintain the discipline and the demeanor and maintain the rules that ad hoc arbitration has also taken into account. So, in short, all I'm saying is that as Mahindras, and first was the farm equipment sector, which started arbitrations before MCIA. Once they saw the success of that sector and the awards coming in, now our Mahindra Trucks and Buses division have started getting their recoveries and other disputes, contractual disputes before arbitration. So this is what I have to share.
Thanks for sharing the success story of institutional arbitration. So what we gather from this experience is that we need to build confidence. Because unless and until we build confidence into the entire process of arbitration, it is very difficult for a party to go for institutional arbitration. Because traditionally we have always thought of ad hoc arbitration is the way to arbitrate, and institution is always perceived as a cost, more costly, and having too much of procedural rules which will govern the arbitration process. Of course, there are exceptions in ad hoc arbitration as well, like what we heard from Dipti is that some of the arbitrators are extremely good and we don't need to go for institutional arbitration. But are we having that kind of a assurance that every arbitrator will do the way the arbitration, it is most cost efficient and a time efficient manner, which we can guarantee in institutional arbitration? And that is where we all need to move, and without the support of the law or the courts, it is very, very difficult. And that's when we decided to institutionalize the arbitration in India. 2019 was the time when the government took initiative and appointed a high-powered committee. I was part of the deliberation of that committee, and we discussed a lot of issues with regard to how to promote institutional arbitration in India. There were certain issues where we have thought of something, and the 2019 amendment has come out slightly differently in terms of what was thought was Arbitration Promotion Council to promote arbitration, whereas Arbitration Council of India has been envisaged in 2019 amendments is slightly different than, rather than promoting, it is going to control the arbitration. So if I wanted to take views from Abhishek on that, is that do you think that the 2019 amendment, which outlines the role of arbitral institutions and also provides for the establishment of the Arbitration Council of India, promotes institutional arbitration in India, or what could have been done differently in the amendment? Because I have my own views, but I would like to hear from Abhishek also. Although this is not notified yet, but if it is notified, then what will be the impact of it, and how it will change the way we arbitrate in India? Over to you.
Thank you, Tejas. Thank you to the Mumbai Center for having me here. And Tejas, I believe our views on this topic are likely to overlap. So, since the question that you've put to me is slightly technical, I will have to trace our steps back to all the amendments that the Arbitration Act has undergone in the past couple of years. But before I do that, for some of my contemporaries or people older to me, I just have an observation. When I joined the bar in 2007, almost every arbitration conference had the same theme. That is, how is the 1996 Act better than the 1940 Act? And we've heard speakers go on and on for 2 days on how the 96 Act is better than the 1940 Act, and it certainly was. I mean, we were excited about the fact that you don't have to make a trip to the court every time you need to initiate arbitration or once you have an award. But I think that was the lowest point of the arbitration conference circuit, and most of you would agree with me. It was like Bollywood in the 90s, it was at its lowest point. And it was only much later in the post 2010 that we realized that we may have come a long way from the 1940s Act, but we are still far behind the rest of the world. And whatever arbitration we are doing here is not because arbitration is a super efficient tool, but only because arbitration is somewhat better than our court system. I think that was the overall takeaway. And it was only when we saw a change in government in 2014 that we started talking about an amendment. And I think it had something to do with the fact that, and rightly so, the government saw a reform in the arbitration scheme as something that would help them improve India's ease of doing business ranking. And so it was not just seen as a reform in law, but it was seen in the much larger context in which arbitration has to be seen. And it was in this context that the 2015 amendments came in, and I think all of us would agree that they were fantastic amendments. For the first time in the history of arbitration in India, we were talking of mandatory timelines. And even though we've had timelines in a large number of statutes, for example, the CPC, the vintage legislation has timelines, and so does the more recent IBC, which, for instance, prescribes 330 days for the conclusion of the entire corporate insolvency process. But subsequent judicial decisions have watered down these guidelines, and they're now recommendatory in nature rather than mandatory. But unlike that, in the Arbitration Act, you had timelines which were firm, and thankfully they continue to hold water even today. For the first time in Section 31A, we saw a costs regime, which was unheard of in India, either in courts or in arbitrations. We saw the fourth schedule, which was the sort of a recommendation to the high courts for determination of arbitrator's fee. And we saw the much needed fifth and seventh schedule. The seventh schedule was a red list for arbitrators who simply could not be appointed because of the relationship. And we had the fifth schedule, which defined the relationships which could lead to justifiable doubts as to the impartiality. We also had the long overdue sixth schedule, where the arbitrators were required to make a disclosure. So we were finally asking questions to arbitrators. We were finally holding them accountable. Before they took on a matter, they had to talk about how many matters they had ongoing, how busy they were, and so on and so forth. And also the relationships, disclose the relationships with the parties in the council. Now it wasn't all hunky-dory, because Section 26, as some of you may know, said that the amendment would be prospective, and that led to a lot of confusion in courts as to whether the amended act would apply to Section 11 proceedings which were pending in court. But despite that, all in all, I think the arbitration, the 2015 amendment was to a great extent a great success, and it did lay down the sort of pathway to successive amendments. Now, I won't trouble you with the 2021 amendments because they were, I think they are relatively insignificant. But just after the 2015 amendment, Justice Shri Krishna's committee on institutionalization of arbitration, which Tejas just mentioned, submitted its report, and that formed the sort of the backbone for the 2019 amendment. And it was in the 2019 amendment that the statute finally, for the first time, recognized arbitral institutions. As Tejas also pointed out, amongst other steps, what the Amendment Act sought to do is set up an Arbitration Council of India, which would, in a sense, be a super regulator of arbitration bodies. And it would accredite not just arbitral institutions, but also arbitrators. Imagine a retired judge in the Supreme Court being accredited by an arbitral institution. And to give all of this effect, Section 11 also had to be amended because the power to appoint arbitrators was now being used by the High Court circuitously through these arbitral institutions. Now, unfortunately, as Tejas pointed out, most of these provisions have not been notified. Even though I understand the first two parts of 43 have been notified, but they are of no significance unless the rest of the provisions of Section 3 are notified. So as on date, other than a handful of provisions, and I will list here, I won't trouble you with them, most provisions of the 2019 Amendment Act have not been notified. now that I've given you some sense on how these amendments proceed, I'll just make a few quick comments before I hand over to Tejas. Now, even though the Arbitration Act now going ahead, still subject to the notification of the provisions, does recognize arbitral institutions, the power vested to them is rather limited. The power is limited to appointing arbitrators. Merely because an arbitral institution is given the power to appoint an arbitrator does not make the underlying arbitration an institutional arbitration. So in that sense, I feel the amendment does very little to encourage parties to actually resort to institutional arbitration. But having said that, I understand the rationale behind accreditation. For the longest time, practitioners of arbitration have complained that we do not have a pool of trained arbitrators. And perhaps the objective behind accreditation is a step in that direction, because the idea that arbitrators now, their prospects or the prospect of arbitral institutions could vary based on their accreditation will make them want to work harder. There is a possibility that arbitrators will now voluntarily take training. And I think the objective behind this whole arbitration council is to ensure that you have a larger pool of arbitrators available to parties who are
notifying these changes. Party autonomy is paramount, because unless and until you leave the parties to decide the way they want to arbitrate, and everybody is in today's world is aware of their rights and what kind of dispute resolution mechanism they want to have. In fact, parties are entitled to select any institution, any seat, governing law, as well as the manner of appointment of an arbitrator, because if you force party to select only accredited arbitrators, then you are taking away their right to select their own arbitrator, which is the virtue of arbitration process. But the problem which we face is that we don't think about all these issues when we draft the arbitration agreement. And that is where we have this problem of pathological clauses or having ad hoc arbitration, although parties could have selected for institutional arbitration. Maybe it is for lack of awareness or lack of familiarity with the better arbitral institutions. So drafting of arbitration agreement is very, very important, and that's where we all have to play a very important role in enabling parties to make the right decisions at the time of entering the contract itself. Because once the dispute arises, nobody wants to agree to anybody's suggestion. Even if you ask for an appointment of the best arbitrator, they will defer on that name, because they think that they may have some connection, or the arbitral tribunal may not be totally independent or impartial. But that may not be true in all these cases, because institutions have no sides to be taken. They are completely independent. They select the best arbitrator who are available to do the dispute. So if I can ask Karishma from both international and Indian perspective, is that how a drafting of arbitration can make all the difference, and if you can shed some light on how to draft an arbitration agreement, whether institution and what all to be kept in mind, especially governing law, the seat versus venue concept, which we have been debating for quite some time. So what are the options parties have, and what best they can do at the time of drafting of the arbitration agreement? Over to you.
Thank you, Tejas, and also to my panelists before for already setting the stage for this part of the panel. So when parties have a dispute, they can obviously go to court or they can arbitrate. If they go to court, then the choice of court is usually obvious. It usually is either where the defendant resides or where the cause of action arose. In the case of an arbitration, it's all up to the parties. So suddenly the parties have to make various decisions about which would have otherwise been made for them if they would have gone to court. And this is what constitutes the arbitration clause or the arbitration agreement. So in that arbitration agreement, they would have to choose the seat. For example, would they like to arbitrate in Ahmedabad, or would they like to arbitrate in Nagpur instead? They also need to choose the number of arbitrators. It's usually 1 or 3. And most importantly, they need to think about, and not enough thought has gone into this, they need to think about the law that the arbitrators will apply to the hearing before them or to the matter before them. This is taken for granted when one goes to court. Courts are governed by the geographical location that they are in and tend to apply the law of the land. And arbitration allows you a choice. So for example, if a party in India had a dispute with a party in the Middle East, and the Indian party said, no, I don't want UAE law to apply, and the Dubai party said, no, but I don't trust Indian law, I don't want Indian law to apply, they can say, fine, we'll arbitrate, let's say seated in Ahmedabad, but let's have English law that applies. So the governing law becomes quite important. Now, there are two aspects that one also needs to think about as far as governing law is concerned. The first is, what is the governing law of the underlying contract? And that is usually specified by most parties. So for example, you can say that the contract is governed by Indian law. But what parties tend not to do is to stipulate what is the governing law of the arbitration agreement. I think what happens is the arbitration agreement tends to be one of the last clauses to be drafted. The parties have already negotiated, the commercial terms of the contract, and they're not really thinking about their dispute resolution clause closely enough. So they put down, yes, we want an arbitration seated, let's say in Mumbai, governed by the MCIA, and the underlying contract should be governed by, say, Indian law. But they forget to put, most often, what is the governing law of the arbitration agreement. And this is important in international arbitrations, especially where the seat is different from the governing law. And I'll give you an example, I'll give you two examples using two heavyweight decisions that have come out of the Supreme Court of England and Wales. That's where I'm a practitioner, so I hope that it will be fine to share with you, beginning with cold foods, quite topical since we're the panel that's separating you from lunch. But cold foods, so one of the parties to the arbitration agreement underwent corporate restructuring. So they more or less stepped into the shoes of the previous party. Now the question was whether the new entity would be bound by the terms of the arbitration agreement. The arbitration was seated in Paris, so it was seated in France, but it was governed by English law. And now you can see where problems are going to arise because the seat is different from the governing law of the underlying contract. The English courts have held, through their Supreme Court, that the new party, so the newly restructured entity, is not bound to the arbitration agreement, and they have done this using English law as the governing law of the underlying contract. The parties have also gone to the courts in France, and the courts in France have actually held exactly the opposite. So the Court of Appeal in France has held that the new party, which stepped into the shoes of the previous party, is bound by the terms and conditions of the agreement, and they did this by applying French law because they said France is the seat and therefore we will apply French law. And so you can see that the French decision is completely opposite to the English decision. The French decision is being appealed to their Supreme Court, which is called the Court of Cassation. This Court Foods case applies a previous decision of the English Supreme Court called Enka and Chubb. In that case, there was a fire in Russia, and there was an arbitration agreement between the insurer and the entity that experienced the fire. There were tort claims that arose out of this, so those claims were not actually contractual. And the arbitration agreement said that any dispute would be seated in England, but there was no governing law at all. So there was no governing law of the underlying contract, no governing law in the arbitration agreement. Now the English Court of Appeal held that the law of the seat, and England was the seat, so the law of the seat would govern the arbitration agreement. But the Supreme Court held slightly differently. So the Supreme Court came up with three hypotheses. This is the Supreme Court of England and Wales. And it's slightly complicated, so I'd like you to sort of stay with me on this. The first two hypotheses are simple, and then the third gets complex. The first is the most straightforward. If the parties have decided what the governing law of an arbitration agreement should be, then of course the arbitrators should apply that law. The second case is that if the parties have not chosen any law at all, and that is what had happened in that case, so no governing law of the underlying contract, no governing law of the arbitration agreement, then the arbitrator should apply the closest connection test. So just think about where the matter has the closest connection, whether in this case it would be to Russia because the fire arose in Russia, or whether it would be to England where the insurers were. Applying the closest connection test, it should be determined. The third, and I told you this is going to be complicated, the third is also the most common. So it's something that we all really need to think about. That is where the governing law of the arbitration agreement is silent, but there is a governing law for the underlying contract. In this case, the Supreme Court held that the governing law of the contract will apply as the governing law of the arbitration agreement and not the governing law of the seat. So it's the lex contractus, the governing law of the contract, that will apply to the arbitration agreement. And the seat, even if the arbitration is seated elsewhere, will not displace the governing law of the arbitration agreement, being the law of the contract. They said that there were two exceptions. The first is if the governing law of the contract invalidates the arbitration agreement. So for example, if the governing law of the contract was English law, and if under English law it invalidates the contract, then English law should not apply, and instead the law of the seat should apply as the governing law of the arbitration agreement. And the second exception was if the seat says, or the law of the seat says, that any arbitration seated in that country should be governed by the laws of that country. And in fact, France is a good example of this, because France simply says, we don't really care about what anything is written as far as the governing law of the arbitration agreement is concerned. If the arbitration is seated in Paris or in France, it will be governed by French law. So these are the two exceptions to the rule. And coming back to drafting of the arbitration agreement, we therefore, I think we've evolved considerably, and we are careful about putting the seat down, we're careful about putting the number of arbitrators, how they should be chosen, etc. But we really need to think about also putting in the governing law of the arbitration agreement. And I'm very happy to say that the MCIA has already considered this, and in their model clause, they include a blank for the governing law of the arbitration agreement is blank, and it's for the parties to put in, but it gets the parties to think about what law to put.
Yes, that's very, very important, because I was just discussing with one of my friends yesterday about Singapore position, and very similar on ENCA versus Chubb, the UK decision. The Court of Appeal in Singapore is going to decide a matter where a contract between an Indian party and a foreign party, the governing law is Indian law, but the law of arbitration was not selected. So what Singapore said is, court said that the governing law of the arbitration will be as per the seat and not as per the main contract. And they said that the proceedings initiated under the Operation and Mismanagement of the Indian Companies Act would not be mentionable, and only the Singapore law, which allows the arbitrators to decide even the operation and mismanagement, will be arbitrable, and only a Singapore arbitral tribunal can decide these issues. This is a very interesting thing, and that makes the drafting of the arbitration agreement very, very important. And you should always treat the arbitration agreement, although it is within the part of the main contract, as a separate agreement and have a separate governing law. If you wish to have a separate governing law, otherwise the seat will take over the governing law, or depends on which jurisdiction we are litigating. But institutional rules are very important, because as Karishma said, you have the model clauses. Each institution provides the model clause, and if you are going for that particular institution, it's always good to have a look at the model clause, because these are time tested. Everybody has tested this kind of clauses, which are very minimalistic. You can add to that, but ultimately it depends on the parties, and you can tailor make those clauses as well, but it is at least a good starting point. But ultimately what we need to also ensure is that the entire process of institutional arbitration culminates into an enforceable award. And unless and until we have an award which can be easily enforced, there is no point, as I said, to go for the entire process of arbitration, winning the arbitration and be ending up with a paper award, which is of no value in terms of money. So the award has to be as good as the award can get you the money which is awarded under the in the entire award. So if I can bring in Vineet here, and from your experience, do you think that the institutional arbitration ensures better enforceability of award, especially in light of the controversy around the seat, curial law, governing law, and all that we have been discussing? Do you think that if we go for institutional arbitration, we have chances of enforcement which are higher than what we have in ad hoc arbitration?
Thanks, Tejas. Audible. So, I think, first of all, of course, India is poised to be a 5 trillion economy. Yeah. So, and even more, considering the fact that contract enforceability from an ease of doing business, rankings and all that is quite critical. I'd just like to say in the beginning that when it comes to, as my co-panelist has also highlighted, the importance of the three laws which generally we tend to ignore that, but there are 3 laws which are there very important when it comes to an arbitration. One is, of course, the proper law which governs the substantive contract. The second is the law governing the arbitration agreement. And the third is, of course, the curial law, the process. I would just like to give an example. In one of my earliest, when I actually, because again, as most of us, I was also generally believe in ad hoc arbitrations. And one of my initial international arbitration, I ended on a losing side, but a lot of learning I had got from that. And especially on the enforceability aspect. And this was an arbitration which was LCIA arbitration, institution was LCIA, and we had in this particular matter on and all that, we were all bullish. At that stage, we have never seen the impact of what is the impact of this proper law governing the arbitration or a curial law and all that. And we were, generally our mindset was that even if there is a issue, there would be an issue, I have all appellate remedies and all that. When ultimately award came against us, then we started discussing with our counsels, what are the options? And then what we had seen, and which was to my complete surprise, was the way these systems, how mature these systems are. If you see the provision of English, there is a provision in the English Arbitration Act, Section 4, which talks about mandatory and non-mandatory provisions. Mandatory provisions are listed in Schedule 1. Now, Section 4.2 says that parties, for non-mandatory parties can have their own arrangement. And then Section 4.3 says that arrangement can be the institutional rules. And institutional rule says, Clause 26.8, I believe the same clause may be there, or if the rules have been further amended. It very clearly says that this award is final and binding, and irrevocable waiver is there for any appeals. In fact, we were really, when we had gone into that, all I think under the sun, every council, my QC, Indian councils, we had studied, gone through that. And we have seen that there is no chance of any kind of an appeal because the non-mandatory clause, actually an appeal on the law point is covered under the non-mandatory clause. So I have only option is serious irregularity under section 68. That covers some 9 grounds which are very, very procedural serious irregularity, which has nothing to do with means your merits of the award and all those aspects are concerned. No, that's a different issue whether we agree with the findings, whether we don't agree. But what it emphasizes or what the point which it has undermined is that this award is a certain for enforcement. There is actually no ifs and buts. It was so clear, the rule was so clear, the law was so clear, which is actually implementing which is giving the kind of a prominence to the institution rules, that the things and again, I don't have an option because the compound interest, the interest is compounded there. So you can't also even go for a flimsy and all that. There's no meaning to that because the interest is going to compound and you know that you don't. Yeah, so ultimately we were forced to settle the matter and close the issue rather than going into any kind of. But what is important? The importance is the way the institution rules were drafted, number one, and the way the institutional rules has been given a clear prominence or some kind of a clear recognition in the law. Both these things are very well, very well set in the process. You agree with that, as respected Solicitor General in the morning has said, that we need to have a convention in between. That is a different issue, whether it should be a New York convention or whether there should be a New Delhi convention or a Mumbai convention. That's a different issue. But what is important is the certainty of that enforcement which was there in that thing. So we had also evolved a lot, but what I was trying to say is that the rules are very important and the law giving the prominence to the rule is very important. The rule has to be firmly institution rules has to be firmly implemented. So if it says that disclosures has to be completed by this much time, it has to be completed by that much time. If it says, again, and very important, both the parties and the lawyers, both has a very important role, what I have seen. Again, it's a learning, as I said in the beginning also, it was a great learning for me. When you frame the issues, or you are framing the issues also. Here, when we go for an ad hoc arbitration, we bring all the issue under the sun, we try to put it. It may happen, something may click. But there, you have to debate with your QC because the QC's reputation is there. So the issues when it is in frame, there's a lot of debate which happens while framing the issues, discussion between the parties while framing the issues. So I still recall there was a issue which we want to say that there's a misrepresentation aspect. And my the QC was very clear that no, we can't take, is it inducement? Do you have the disclosure to prove that how it is an inducement? Then only I will take misrepresentation. Rather than in normal thing, okay, we'll take the issues, we'll come back with the evidence and all that. So the responsibility and accountability of the stakeholders also is important. If all these things are taken care, that means the rules firmly implemented, the rules have the recognition in the law, in one, as I said, section 4.3, read with to 26.8 of the NCIA rules. And the accountability and the reputation of the councils attached with the process. I think then the enforceability of from an enforceability standpoint, institutional arbitration is the way forward.
And that's so true, because we all seen in practice is that we have tried to enforce ad hoc arbitration and institutional arbitration awards, and we have seen because of the advantage of the institutional arbitration, because the awards are scrutinized, or you have the better quality of arbitrators and the process being followed, because most of the ground for setting aside or refusal to enforce is that the process of arbitration was not properly followed, but you have that guarantee in the institutional rules. We have a limited time. We'll just have a quick round of second question to my panelists, and then we'll leave some time for question and answer. So if I can ask Dipti from her experience, although you shared that you have a great experience with MCIA, but why are you not selecting, for example, I'm going to take names, but a foreign arbitral institution vis-a-vis Indian arbitration institution? What do you see the difference? Like, what's your experience that the Indian arbitral institutions are promoting arbitration? Are they good enough? Do they need to do something differently? Or you are happy with your experience with MCIA?
Yes, I definitely am happy with my experience with MCIA, but a lot of our arbitrations at Mahindras are domestic, and therefore we prefer domestic institutions. There are 2 or 3 things that come to my mind. One is emergency arbitrator appointments, which helps in appointing arbitrators in a day's time, if required. The second thing that comes to mind is allowing consolidation of arbitrations, which have a same party, same disputes, etc. Just one very small example, we had charter party agreement and we had recovery under the charter party agreement. We filed for that recovery under the MCIA Act and in MCIA, and then the other side filed a counterclaim which was under a different agreement, a hire purchase agreement, for example. So we contested that and we said that since the contracts are different, they cannot be under the same arbitration. They cannot be under one. So they filed a fresh claim. However, because it was institutional arbitration, we were able to consolidate, and the hearings are going to be under one arbitrator, hearing 2 different disputes. So that helps as well. And the other thing that I found at COVID times was that I was able to conclude arbitrations. In 20 and 2021, I was able to conclude arbitrations which were filed because of virtual hearings, online filings, etc. There were so many courts which had stopped functioning. There were very few courts which were functioning virtually. So that also helped. So these are the few benefits that I believe why I would choose, not just MCIA, but if there are more arbitral institutes which are going to come up, we can just see, I am more aware of MCIA because I am Mumbai-based, our arbitrations are domestic and more or less Mumbai-based.
Thanks. No, that's true, because if you have the advantages of emergency arbitrator or consolidation, that plays a very important role, because for the same set of contract, if you have multiple arbitration, it leads to additional cost and contradictory awards. So Abhishek, if I may ask you, you explained about the law, but what do you think the role of the courts for promoting institutional arbitration is? Because ultimately we have to go to court at some point of time. We cannot avoid, especially in Indian mindset, from going to court. So what is your experience in terms of the court supporting institutional arbitration?
Thank you, Tejas. I'll just take 1 minute to answer this question since we are running against the clock. I think the way our Arbitration Act is structured, there are very limited opportunities for courts to interfere in the arbitration process prior to the commencement of the arbitration, be it at the 8, 9 or 11 level. So I don't think there are too many avenues there for courts to interfere. But having said that, I think the courts have a persuasive role, particularly while exercising Section 11 jurisdiction. And we find that a large number of cases which are referred to arbitral institutions such as the one here in Gujarat or the one attached to my home court at the Delhi High Court are actually matters which come up in Section 11 and where the court is able to convince the parties to adopt arbitration vis-a-vis ad hoc arbitration. So I think there perhaps the courts do have a role, but in the larger scheme I don't think they have a big role to play. On the judicial side, I think the biggest role that the courts can play, and this would apply to ad hoc arbitration as much as to institutional arbitration, is to have a hands-off approach. Thankfully, we've been seeing a great deal of that. And the New York Convention talks about something called the pro-enforcement bias. And I'm glad to see that bias in our courts now, even though I've been the victim of this, and I'll be very quick in sharing this example with you. This was, of course, prior to the 2021 amendment, which states that in case of fraud, the award can be stayed without any conditions. So I had a client that called me up one day and said that they have received a letter from their banker, and that letter informs them that they are going to attach the bank accounts of my client. And apparently this has been done pursuant to an interim award. And my client had no clue about this arbitration proceeding. And when we finally managed to track down the arbitrator and got a copy of the record out, it turned out that our client was the victim of a massive fraud where somebody had set up a false arbitration, had fabricated an arbitration agreement, had set up an arbitrator. An arbitration notice was sent to an address which did not belong to my client. A person was set up who appeared before the arbitrator with an authorization from the board and said that he did not oppose to the interim award being granted, and the interim award was nothing but whatever was claimed in the arbitration proceedings which had been given at the interim stage itself. And the remedy available to us was to, of course, challenge that award, and this challenge would lie to a commercial court at the subordinate level in a suburb of Delhi. And for the first 2 days, the judge wasn't holding court. When we finally managed to drag him to court, he said, issue notice, come back to me after 3 months. And my client's bankers were knocking at the doors and they wanted to attach accounts. And of course, the next day we moved to the Supreme Court, and Justice Nariman took half a second to stay the award. But by the time we could achieve all of this, 12 crore rupees had already moved out. And of course, we are pursuing it, the FIRs and so on and so forth. But my client is poorer by 12 crore rupees only because of the pro-enforcement bias, because nobody was willing to touch an award. And so I just wanted to point out that it works both ways, but more often than not, I'd much rather have the bias working in my client's favor when they have an award rather than the other way around.
Of course. So Karishma, I know the time is up, but very quickly to ask you how in these last 2 years the arbitral institutions have coped up with regard to the best practices, and do you think there is a need for any specialist arbitration institutions?
Thanks, and Abhishek, thanks for sharing that most bizarre example. But taking from that fraud, so perhaps that's a good starting point for what I'm going to say. Civil fraud, and now increasingly a lot of technology fraud, whether it's crypto fraud, email compromise fraud. A lot of corporates are sort of faced with email compromise frauds where they pay money into accounts that they believe belong to their vendors or suppliers, but actually that account belongs to someone who's a fraudster. So in such cases, I've found that when I am in front of a judge, not all judges understand the technical aspects of the underlying technology or the blockchain or whatever it might be. And this is one thing that I think institutions really need to take the bull by its horns. They might want to set up, as the MCI has done already. Before I can make suggestions, the MCI has already put things in place. So Neeti told us about the user councils that they have. What I'm trying to say is we need sector expertise amongst the arbitrators as well. So whether it be cement, technology, etc., whatever it is, it's worth thinking about that, and arbitration institutions during the last 2 years have started to think about that and put, as the MCA has done, user councils in place. The second point, very quickly, is virtual hearings, which of course everyone has had to do, but arbitration institutions have really taken many leaps ahead insofar as virtual hearings are concerned, and a Queen Mary University survey that was done recently said that nearly 80% of parties responded to say that if a hearing could not proceed in person and if it had to be a virtual hearing, they would proceed at the scheduled time. And only 16% of them said that, we would adjourn it until such time that it went in person. So those are two very quick adaptations that institutions have made.
Thanks. We are all surviving because of virtual hearings, otherwise we would have been all redundant. Lastly, Vineet, I can ask you for these 30 seconds, the concluding thoughts on what efforts we can make to make institutional arbitration more acceptable.
So, Tejas, if you ask me what efforts, of course the efforts are all going on, but the very important aspect which I see is basically the maturity and pragmatism in our from our fraternity, be it in-house counsels or lawyers, and in fact the clients also. Because one has to understand that we always carry the baggage of the normal court-route litigation, which always, and probably our preference for ad hoc arbitration is basically for that only, because you get a lot of flexibility to seek adjournments or whatever it may be. That kind of a flexibility would be there. But we have to understand that this is all about ADR. ADR means dispute is coming in the middle in that word, but alternate and resolution, they are very important. It should be something which is alternate, which is not a substitute. It's an alternate, so it should be a different aspect. So when you see it from that standpoint, since the time is also a constraint, I would say predictability is very important of the rules, which I had emphasized in the beginning also. Capability of the panel. Again, that is something, of course, distinguished panel would be there, but now if you see, our country there's another kind of a dynamism which is coming up. We are foraying into digital, we are foraying into areas like fintech, banking and all that. Probably these are the new age or e-commerce for that matter, gift city. India is poised for a financial center. So considering these kind of segments, probably these are the areas where the institutional arbitration should try to come up with better protocols in relation to that and try to say that if we can have a first mover advantage as far as the institutional arbitration is considered in these particular sectors. Acceptability is also very important. When you say acceptability, government is one of the biggest litigant. If government actually recognizes institutional arbitration, I will give you one example. A lot of states go for state incentive policies. And most of the incentive policies ultimately land up in High Court or Supreme Court on promissory estoppel, because after getting it, they don't give it. And most of the times you have that supervening public interest, this and all that. But if these incentive policy has an institutional arbitration related clause and government recognize the importance of that, then probably these kind of areas are very important which can be solved. And if government actually uses institutional arbitration frequently, this whole ecosystem will grow like anything. And of course, efficiency, flexibility, balance between flexibility and firmness in enforcement of the rules and all that is important. I agree with the other panelists also and in the discussions in the morning that cost is not a hindrance, because ad hoc arbitrations also the cost goes like anything. Here it's at least there is a certainty. So I think and when you select a panel for the arbitrators, there needs to be some kind of an objective rule, no scope for discretion. The way the rules would be there for selecting the panel, because it has to address various industries. So all these aspects, if the herd is in the right place of whatever efforts are being done, then probably I see a lot of change.
Thank you for summarizing it so well. With that, I thank all my co-panelists for their thoughts and all of you for listening to us so patiently. Thank you so much, everyone. And I'm sorry there's no time for Q&A, but because we are already running short of time, so we'll just wind up the panel. Thank you very much.